Hello, everyone, and welcome. Thank you for joining us for today's Perspectives in FTD Research Webinar. Today's webinar is about navigating social and legal challenges in familial FTD. This webinar is being presented jointly by the Association for Frontotemporal Degeneration and the FTD Disorders Registry. My name is Kim Jenny, AFTD's Manager of Genetic Initiatives. Thank you for joining us. Before we start, I do have a few housekeeping notes. First, the audience will be muted throughout this webinar to reduce any background noise. If you encounter any technical issues, click the Q&A button and write a message explaining your problem, and someone working behind the scenes will try to resolve it. Time permitting, we'll try to answer your questions at the end of today's webinar. Just click the Q&A button to submit your questions. We'll try to get to as many as we can. Finally, this webinar will be recorded and archived for later viewing on the YouTube pages of both AFTD and the FTD Disorders Registry. This Perspectives in FTD Research webinar is made possible through the support of Aviato Bio. Thank you to the folks at Aviato Bio for their generous sponsorship of our work. I also want to acknowledge AFTD's partners at the FTD Disorders Registry, a powerful tool in the movement to discover treatments and a cure for FTD. The registry relies on stories of people like you. Your stories and experiences will help to spur innovation that will lead to effective treatments and therapies. We're excited to let you know that the FTD Disorders Registry has undergone a major platform upgrade that will improve and expand its capabilities, including enhanced security and more customized information based on a person's FTD type or genetic cause. The registry is hosted on a secure platform that follows comprehensive measures to protect your information. The FTD Disorders Registry advances the science towards a cure for all FTD disorders. By joining the registry and sharing your insights and lived experience of FTD, you will help drive the research forward. The registry uses a secure web-based system with all data controlled by the registry nonprofit team, who are dedicated to advancing clinical research. When you join the registry, you will be kept informed about trials and other studies seeking participants that match your interests. If you participate in an FTD Disorders Registry study, your responses enter a secure portal. The registry study helps researchers better understand your lived experience across the entire spectrum of FTD disorders. Anyone impacted by FTD is welcome to join the registry. This includes family members, care partners, and friends. All data is de-identified, meaning there's no connection to your name or other identifying information. Participants' personal information is never shared. If FTD has touched your life in some way, I strongly encourage you to join the thousands of people who have already signed up for the registry. Registration allows you to receive periodic news and FTD research updates by email, as well as notifications to participate in surveys and research studies to help further the science of FTD. Visit ftdregistry.org. Finally, AFTD's 2024 Education Conference is taking place 1 week from today on May 3rd in Houston. This annual conference brings together persons affected by FTD, experts in the field, and other healthcare professionals for a full day of learning and connection. It's not too late to sign up for the free live stream, which allows you to watch live and interact with fellow attendees. Visit the link on the screen and register today. Our guest presenters today are Jalayne Arias and Laynie Dratch. Jalayne is an associate professor in health policy and behavioral sciences in the School of Public Health at Georgia State University. And Laynie is a genetic counselor in the adult neurology program at the University of Pennsylvania. They'll be joining us shortly, but first I'd like to share a brief overview by what we mean by familial FTD. Not all FTD is genetic. For the majority of people diagnosed, roughly 60%, they are the only person in the family with FTD, and there's no history of anyone else with FTD or a related condition like ALS, a psychiatric diagnosis, or a language or movement problem. We refer to this as simplex or apparently sporadic FTD. When 2 or more people who are related by blood are diagnosed with FTD or one of the related conditions, we refer to this as familial FTD. These families make up about 40% of our community, and in these families, there is a greater chance of identifying a genetic cause. There are many genes that cause FTD, and likely more to be discovered. The 3 most common genes include chromosome 9, open reading frame 72, or C9orf72, the microtubule-associated protein tau, or MAPT, and progranulin, also called GRN. C9orf72 is believed to be the most common cause of genetic FTD, and it's the most common cause of genetic ALS. Most of these genes that you see listed here can present with any of the symptoms associated with FTD. This means in one family, you may see a person with behavioral changes and another relative with a language problem or ALS or another movement disorder. And this contributes to the difficulty in getting a prompt and accurate diagnosis of FTD. To date, genetic forms of FTD are inherited in an autosomal dominant manner. Autosomal dominant refers to a genetic condition that's passed down from either the egg or the sperm to a pregnancy. With dominant inheritance, a person is at risk for FTD when just one copy of an FTD-causing gene has a pathogenic variant, formerly called a mutation. With dominant inheritance, males and females are equally likely to be affected. And a person with genetic FTD has a 50% or a 1 in 2 chance to pass on the genetic variant. Each pregnancy has the same 1 in 2 chance. Genetic counseling can be helpful for any family impacted by FTD, whether it appears to be familial or not. A genetic counselor can help you learn more about FTD and review your family history to understand the likelihood it may be genetic. If you pursue testing, a genetic result can confirm that FTD is the correct diagnosis. And by understanding if FTD is genetic, it could influence the way you and your relatives approach several important life decisions, including family, career, and financial matters. And in some cases, a genetic result may open up opportunities to participate in research focused on developing a treatment for FTD. It's important to remember, genetic counseling does not mean you have to be tested. Testing is not for everyone. A genetic counselor can help you weigh the various considerations for how your results may impact not only you, but other family members. Part of a genetic evaluation includes a review of any related medical records for yourself and, when available, for any relatives who are potentially diagnosed with an FTD disorder. The information you share contributes to a comprehensive and accurate medical evaluation. It's important to think about how to get your medical records safely to your healthcare provider. Our health information is protected by several laws that we'll discuss today, but each person is also responsible for protecting their own information. You can ask questions about who has access to your medical records and why. Most health organizations, hospitals, and some private practices will have a secure portal where you can safely share your medical records with your healthcare provider. We do recommend that you use caution before sharing personal health information by unsecured emails, on social media, or in other public forums. It's important to be thoughtful about how, why, and where you share medical information to limit any possible exposures. Today, Jalayne Arias and Laynie Dratch will review several important factors to consider, including different ways to access genetics and the protections and pitfalls of some of the laws meant to protect your privacy and prevent discrimination. And now, I'm pleased to turn things over to Jalayne Arias.
Yeah, go ahead. Hello, and thank you so much for having me today. Give me just one moment as I prepare to share my slides. So thank you so much for having me today, and I'm excited to be able to share a little bit of information today about navigating social and legal challenges in familial FTD. And really pleased to be here representing Georgia State University, where my team focuses on the legal, ethical, and policy issues associated with dementia and aging conditions broadly. So just as a disclaimer, today's webinar should not be considered or used as legal or medical advice. If you have specific questions regarding your own individual situation, we do encourage you to seek professional legal or medical advice as appropriate. The information provided by the speakers, including myself and Laynie, really should only be to provide a general understanding of the topic. So what I'm hoping to do today is provide some insight into how some of the legal and policy structures really focus and work in this area in order to provide you with a little bit more context that when you do have conversations, either with your medical provider or with a legal professional, that you have some background or context to guide those conversations. So I think it's important to recognize that, and I think many on this call already do, that familial risk for FTD may lead to complex social and legal challenges. And this is generally something that we see across neurodegenerative illnesses, particularly for those that are at risk for neurodegenerative illnesses. So this is a quote that I heard from a clinician when we were conducting qualitative interviews to understand how they might think about this idea of establishing a pre-risk score or pre-disease test in somebody who is asymptomatic. This is actually specific to Alzheimer's disease. However, I think that this thought really cuts across, which is there is this sort of misunderstanding that legal protections apply broadly across all circumstances when somebody is at risk for a disease. And certainly we know that there are laws in place that help provide these protections, but I think it's important to understand that particularly at the federal level, there are some gaps in our legal system that could expose some individuals to risk. It's also important to understand that what we mean by legal protection, I mean that there's different kinds of protections for different purposes. So there are privacy protections. We often think about HIPAA as a privacy law, which prevents individuals from intruding into another person's information. So these are legal protections that would protect somebody's medical records so that not just anybody has access to it, right? This is different than protecting confidentiality, which confidentiality really means that it's the clinician or other stakeholders' responsibility that if they do learn private information about an individual, that they do not disclose or share that information with others unnecessarily or without permission. And then there's another side of protections that are different than the protections that we have around our data, which are these anti-discrimination protections. So these anti-discrimination protections assume at some level that an employer or insurer might know information about you or another third party. And these laws actually prevent those actors from using that information adversely against an individual. And we do also know that there's different protections depending on whether or not you're in research or you're in clinical care. So we typically think of research information as more protected than healthcare information for a number of different reasons, including we want to encourage people to participate in research. So a lot of times we will even think about how do you establish from a very practical level, confidentiality protections around research data. That's a lot of times why we think about de-identifying data. This is different than how we might think about healthcare information, where healthcare information is being collected about a patient or about an individual in order to advance their care. And in that context, there's logistical and sort of like health-related reasons as to why we actually want our information to be able to move between providers. So for example, if your primary care physician is able to provide baseline information to a neurologist, that can often be helpful, and vice versa for the diagnostic information from a neurologist to be able to go back to a healthcare provider. So there's different protections in different places that I just emphasized. And one thing to recognize is like there are different federal laws that cover those areas. So some of the ones that I'll talk about today include HIPAA and GINA. In the research context, we also have the common rule, which establishes an extra layer of protection around research results. And in the clinical context, it's important to consider the following protections. So first, in the context of privacy, we do know that GINA, the Genetic Information Non-Discrimination Act, protects against employers asking for genetic information. So again, this is specific to a familial risk of FTD. For example, if you are genetically at risk for a disease, employers are actually unable to ask about that information. And that we also know that at the state level, different states might extend additional protection. In the context of confidentiality, this is something I recently just mentioned, but HIPAA restricts who has access to personal health information and how your health information can be shared and for what purposes. And then GINA, in the genetic realm, we see that GINA provides protections where it prohibits employers and health insurers from using genetic information. Similarly, the Affordable Care Act prohibits health insurers from using pre-existing conditions during underwriting. These are both important protections in the context of somebody who's at familial risk for FTD, as it protects that health insurance. It protects or makes sure that individuals maintain the ability to access health insurance. However, there's some elephant in this room, which is really that one of the primary laws that we rely on for genetic protections, which is a driver for FTD familial risk, is not actually comprehensive in the way that we would hope that it would be in order to make sure that individuals are protected across all platforms or across all in all circumstances. So just as some background, big picture, GINA was put into law into 2008. The general goal of GINA was that there was a concern as genetic information or genetic testing became more readily available that people would be dissuaded or discouraged from using genetic information to advance their health if they were concerned that they might be discriminated against based off of that information. So really the law aimed to reduce discrimination in those contexts. However, it's important to recognize, one, how genetic information is defined, which is it's defined to include information from genetic tests and the result of family members' genetic tests. And it has two primary titles. The first prohibits discrimination based on genetic information in the health coverage, meaning health insurance. And then the second title provides protections in the employment context. And why I say there's an elephant in the room is that a lot of times we attribute a significant amount of protections to GINA that may not actually exist under that law. So here's some critical gaps to be aware of. So first of all, GINA does not apply to long-term care, life insurance, or disability insurance. As a result, and these insurers are able to use that information if they get it when making things like underwriting decisions. So it's really important to understand that caveat. Second of all, GINA only applies to a subset of employers, so specifically to employers with more than 15 employees. It's important to note that over 17 million people in the country, or 15% of employers, might not meet that definition. And then also, GINA ceases to apply at disease manifestation. This is not well defined in the law, and it's been a source of legal scholarship to try to better understand what it means for a disease to manifest. In an era where neurodegenerative illnesses are advancing towards early detection tools that include biomarkers, one thing that's unclear as to whether or not the identification of a biomarker would indicate disease manifestation if it represents disease pathology. So essentially what I'm trying to say here is that once the disease becomes active, right? So if you are genetically positive for a disease, you would be positive throughout your entire life. At some point that disease becomes active, GINA protections no longer apply. And because research has been, and importantly, been moving the field forward as far as creating an earlier diagnosis, there's some ambiguity around what we mean by disease manifestation and when those protections would cease. Additionally, there's a lot of other ways in which employers may get access to genetic information besides making a request. So it could be through an inadvertent disclosure, it could be part of a wellness program, or it could even be something as simple as being justified, where genetic monitoring is critical for things like evaluating the effect of toxic materials in the workplace. So while GINA protects against employers being able to request your genetic information, that doesn't mean that they still won't learn it. There are protections in place that prevent them from using it. However, there's a lot of research that shows that some discrimination may not be explicit, and so there's that you want both protections in place. So it's important to understand sort of how long-term care fits in here and why it's so important to think about the potential risks of for familial diseases and for individuals who are genetically positive for familial diseases specific to long-term care services. So long-term care services are different than healthcare and medical services. These are non-medical services provided to individuals, generally aimed to assist with activities of daily living. These include home health and long-term care residential settings. For many who have had familial exposure to dementia, including FTD, they're aware of the importance of these services to be able to reduce caregiver burden and also provide needed support to patients. And it's also something that we know is incredibly expensive. So working with Jing Li from the University of Washington and other collaborators, we actually were able to quantify using a national database that in fact, out-of-pocket coverage for long-term care services, particularly for those with dementia, is incredibly cost prohibitive and actually can have a major impact on individuals' incomes. Our study actually demonstrated that a significant portion of individual incomes were going to long-term care services that were being paid for out-of-pocket. And so why is this such an issue, and why is it so expensive, and why are we paying so much out-of-pocket? It's important to understand that, first of all, Medicaid does not cover, or Medicare, I apologize, Medicare does not cover long-term care services. Medicaid is the primary payer of long-term care services in the United States. However, in order to qualify for Medicaid, one has to do the spend down, and there's some access barriers as well there. So that would seem like it would be a prime area for private insurance markets. However, what we know is that the private insurance market is both failing and that as a product is not really always the best option for everybody. And one of the reasons why is that there's a high rate of medical denial, which leads to low purchase rates. There can also be a poor benefit structure with minimal external benefits, and there can be high rates of medical denials, as I just said. One of the things to consider if you are evaluating a long-term care insurance policy are the limitations on benefits. So for example, some policies may have elimination periods, meaning what is the period of time an individual must wait to access after they initially meet benefit triggers. Benefit triggers are this qualification criteria that must be met before an individual is eligible for benefits that is usually based off of assistance with ADLs, activities of daily living, basically saying that an individual needs to have a certain level of care needs before they're eligible for accessing. And then even once they meet those care needs, there may be a period of time before the insurer will step in. And also one of the more critical components is that there are huge benefit caps, meaning that there may be daily lifetime or aggregate caps that limit the amount of coverage available for an individual. And so when we look at this and we think about it, the other big barrier that we have when we think about the availability of long-term care and how it fits into familial risk for disease is that there are laws in place that allow for insurers to use your health information during the underwriting process. So when they are making a determination about whether or not you are or not eligible and what your premium rates will be, unlike health insurers, which have prohibitions in that area based off under the ACA, in the context of long-term care insurance, it's actually an area where insurers are able to use that information before making a decision, again, about whether or not they're going to offer you a policy and whether or not what your premium will be. And we've already heard in our data from other patients and from caregivers that once there's an introduction of the potential risk or an early sign of dementia, that patients have been declined long-term care insurance. So we do know that the good news is that there are federal and state policies that are emerging. We are actually doing a study in my team right now led by Mary Manchester, looking and trying to understand what kinds of policies are emerging at the state level to assure or provide for long-term care services. Additionally, we know that the Biden-Harris administration has been including this as a policy area. So I think while what I just said and shared about the underwriting process for long-term care services insurance is a little grim, we do know that this is something that might change, and we might be able to have better access to long-term care insurance or long-term care policies through different mechanisms. However, we do know that future work is needed to understand whether and how these policies would affect individuals and families needing services due to FTLD. And part of this is because of the component of FTD that affects young onset or has a young onset impact. So what's unclear right now is that when we do think about some of these policies that have been emerging, and I have an example here, is whether or not they would they fill the gaps left by GINA and other laws, but may not be sufficient as is. So one of the questions that has emerged consistently is, could we just extend GINA into other areas, and would that be sufficient to provide the protections that we would need? When looking at some of the questions, like, for example, if a state law extends protections under GINA to decrease the number of like minimum employees needed, right? So if it's, you just have to be any employer is required to, or is prohibited from using genetic information, would that be sufficient? The question still emerges is like, how is that applied in other contexts, and the question about a disease manifestation. So one recommendation is to really think about two components. One is thinking about both planning long-term. So if you do have familial risk for FTD, thinking about working with an elder law attorney to understand what the potential options are for you, and a financial advisor to think about the options that might be available to you for planning for the future, and certainly understanding how to integrate some of these decisions into an advanced directive. This is particularly important if you have specific values or wishes that you would like about how you receive care after you've lost capacity, or with the potential that you lose capacity. And so I always use this. I was a clinical ethicist for several years, and I always use this as a reminder that your living will and your power of attorney are two documents that you can use to assure that how you are cared for throughout your life matches with your values and wishes. And so really understanding like how decisions are made, both in the context of healthcare and long-term care services, is critical to know. So first of all, healthcare providers will look to identify who a decision maker is. Typically, if a individual does not have a advanced directive, that is actually determined through the next of kin structure. So for example, some states actually have hierarchy statutes. California does not have a default surrogate statute, but they have other mechanisms in place. That was just one example of understanding how state laws might impact individual experiences. And then once you determine who the decision maker is, typically that is who will be making an effort to make decisions on a patient's behalf. That would encourage them to use the substituted decision maker and then the best interest standard. So a substituted decision maker, if you're a caregiver or the next of kin who's making a decision, it's really your role to step into the shoes of and the values of the person that you're making the decision on behalf of, and make decisions that are consistent with that. So just want to say thank you to my team, and also the funding that I've received to be able to support some of the research that we've done. And thank you to AFTD for inviting me to present today.
Hi, everyone. I'm just going to figure out how to get my slides up now. Let's see. Okay, hopefully the slides are now visible. Can anyone from IFTD just give me a verbal yes that we're good, or a chat?
They're on the screen, but they're not in presenter mode.
They're still, okay, they're still not in presenter mode?
Correct.
Okay, let me figure out how to get out of here. And oh, I see what the issue is. Hold on one second. You would think I'd be better at this by now. I'm going to share this screen and then do that. Can you now see them?
Yes.
In the right way?
Correct.
Perfect. Okay, thank you. So hi, everyone. My name is Laynie. I am the genetic counselor at the Penn Frontotemporal Degeneration Center. And thank you, Jalayne, for a wonderful introduction to a lot of really complicated topics that come up quite frequently when people are considering genetic testing in FTD. Just a couple of quick disclosures. I do have some consulting relationships. So today I will take you through a little bit about what the difference is for diagnostic versus predictive genetic testing and how some of these legal concepts come into play differently in those two scenarios. I'll also talk to you a little bit about the difference between clinical and research genetic counseling and testing, and again how the method by which you approach genetic testing impacts some of the legal considerations as well. And then we'll talk a little bit about how you can best prepare given these concerns. So just to start, diagnostic genetic testing refers to when a person who has a diagnosis, so in this case of FTD, or symptoms suggestive of a diagnosis of FTD, undergoes genetic testing to try to figure out a reason for why their symptoms have developed. Predictive genetic testing, on the other hand, is when a person who is part of a family with a condition like FTD, but doesn't have any symptoms themselves currently, decides whether they want to go under genetic testing to see if they inherited risk to develop that condition in the future. And so you can imagine why these two types of tests are quite different from an emotional perspective, but also they have key distinctions in terms of what legal protections are important to keep in mind as well. So when people undergo diagnostic testing, they might be trying to get an answer to why their symptoms developed in the first place, to end a diagnostic odyssey if it took a really long time to even figure out what was going on, which unfortunately is quite common in FTD, to gather information that can help them figure out, future medical needs and what to expect for their care, and to get access to more targeted supports and research, potentially even trials or approved therapies someday, and to provide information to the family, which is what then informs the ability to undergo predictive testing. And so sometimes people think about learning their genetic risk status through predictive testing to just reduce the uncertainty. They feel like they need to know, did I inherit this risk or did I not? They might want to use it to plan for future things in their life, like how they want to have children, whether they want to have children, what they want to do for their career or financial planning, to provide information for their own children if they already have them, and to, again, access support, research, etc. But some people feel they really don't want to know their genetic status because emotionally it would be hard to grapple with that information. They might feel like if there's no medical intervention for me right now, what's the point? They might also have concerns about discrimination, many of the key things that Jalayne just talked to us about with regards to insurance and employment. Or they might be worried about impact on relationships and stigma that may come from learning one's status. So I just wanted to set the stage a little so you know some of the terminology that we're using and you can think a little bit about how these two scenarios might differ. And now we'll focus on how they'll differ from the legal perspective as we consider clinical and research scenarios. So there's two main ways that people can access genetic testing. One is clinical care and one is research. So I'm going to start by giving you a little bit of information about the clinical route. So when you do genetic testing through clinical care, it's just like any other medical appointment or medical test that you would do, where the testing is ordered by a medical provider. The results and any notes documentation will be part of your medical record with your true name and date of birth and other identifiers on it. And this is the type of testing that can be absolutely used for any sort of medical management or medical decision-making because it's done in a CLIA certified, federally regulated laboratory. It's done to the standards of clinical care. And so in this situation, through clinical care, cost is often billed to an insurance company or to the patient if there's out-of-pocket cost after insurance coverage. And the results come to the clinician that ordered the testing, and then they're reviewed with the patient if they want. And so let's think about what are the legal implications in a clinical scenario based on what Jalayne outlined for us with regards to the protections that do and don't exist. And we'll talk about it both from the diagnostic and the predictive standpoint. So for a diagnostic standpoint, again, that person already diagnosed with FTD or a related condition, they already have a diagnosis. And so having that information entered into your medical chart of now we also have a genetic result, we've got an FTD diagnosis and now we have a genetic cause for why. That's not really going to change anything from an insurability standpoint. The Genetic Information Non-Discrimination Act, or GINA, no longer applies because, as Jalayne told us, once you become symptomatic, those genetic discrimination rules aren't applicable. And so the results and your notes are protected by HIPAA like any other medical information. And so really there's not a ton of concern about adding genetic information to the chart for somebody who's already had a diagnosis of FTD or a neurologic condition. However, on the flip side, for people who are thinking about predictive testing, who currently don't have symptoms themselves, these rules really do matter. So GINA, the Genetic Information Non-Discrimination Act, does apply, which, as Jalayne told us, means your health insurance and your employer, in many cases, but not all, can't ask for or use your genetic information against you. But if you were then to apply for a new life, long-term care, or disability insurance policy, they could deny you coverage. And again, your notes and results would be protected by HIPAA, just like any other medical records, but there are limitations to the protections that exist as defined by GINA. There are some state laws, like Jalayne mentioned, that have additional protections, but GINA is the one I'll focus on here. So I'm just going to go through a couple of frequently asked questions that relate to clinical counseling and testing. So sometimes people will ask, if the person in my family with FTD or ALS or whatever it may be undergoes genetic testing and has a positive result, can this automatically impact their relatives' insurability? And so the answer is not immediately. So when the person with FTD or ALS undergoes genetic testing, clinically, the results are entered in their medical chart. The family members, if they go and tell their own doctors or own medical providers, hey, my loved one had a genetic form of FTD found, then it gets documented in their medical chart, and that's when it can start to cause issues for them, even if they don't undergo testing themselves. So it's really important that before an at-risk person communicates this information to their medical providers, they think about what insurances they have and what they may want in place someday to make sure they're protected. Or you have a conversation first with your medical provider and say, hey, I want to give you some information. I'd prefer it not be documented. Is there a way we can talk about this before it's documented? I would never want someone to not feel comfortable communicating with their clinicians. It's really important that your doctor's made aware of the family history and the genetic risk so they can make a care plan with you. But it's really important to first think about the limitations of these protections before that gets into your own medical chart. Another question sometimes people ask me is, if I'm at risk and I want to speak with a genetic counselor, but I just don't want anything in my medical chart yet, what can I do? And so the options might vary based on what location you're at. I can speak to what I can do as a genetic counselor at Penn. And many genetic counselors can do the same thing, but not everyone has the same workflow. One of the things that I offer is, if a person that I'm counseling with FTD or ALS has been found to have a genetic cause for their condition, I offer what's called a family follow-up visit, where I offer them to have a follow-up visit with me. And so it's their appointment, still the person diagnosed appointment, and they can invite whatever family members they feel comfortable inviting to join in that visit. And then those family members get access to me and all the information and questions they have without anything being documented in their own chart, because everything's still under the patient's chart. This only is available when the genetic counselor has the ability to do these family follow-up visits and when family dynamics allow for this. Not everybody has the same communication dynamics or comfortability in having a family visit like that. But so one thing that any genetic counselor can do is have a brief phone call with you where it's not a formally documented visit. They can just do some upfront question and answering and help point you in the right direction for where can you access counseling and testing, and what questions you might have ahead of time before you schedule anything and get that information in your medical chart. It can't be a formal undocumented visit, but it can be a brief introductory call. Another area that we'll talk about next is research. Some research studies include the option to have genetic counseling with or without testing as part of research protocols, where everything is documented in research records and not necessarily in the medical chart. So we'll come back to that in a moment. If I'm at risk and already have life or disability insurance through my employer, am I good? Just want to point out that there's a difference between the employer-provided plans and private plans. So usually the employer-provided plans don't require any medical record review. We're really talking about if you're applying for a new private life insurance policy, for example, that's when they might request records. And what insurances you want is really up to each individual and what your goals are for your insurance. And sometimes people wonder if paying for testing out of pocket or going through a no-cost program avoids the problem, and really it doesn't. Because even if you are seeing me clinically and we send testing and you pay self-pay, I'm still documenting our notes from our visit. It's a legal issue. You can't not document the visit. That's something that isn't really quite a workaround. So let's switch gears to research. So the other way to access genetic testing sometimes is through research study, but not every research study is created equal. They all have different protocols. And so it's really important when you're joining a research study that you ask all the questions you have about the genetic testing process, especially so you know what to expect. And so the research, typically, everything is paid for by the research study. There should be no cost to you. And typically, the testing is done under a research name, rather like an ID number, rather than your true name. Where the records are stored depends on the research study and the institution. For example, some of the studies that we have going on at Penn, even if there's other information that's linked to the medical record through the study, we're able to keep the genetics information from the research study separately in paper files, completely not in the medical chart. That's not going to be the case for every protocol in every institution. And whether or not you can even get access to the results would depend on the protocol. So some research studies allow for the return of research results if they're done in a CLIA certified manner, which is the same federally regulated way that clinical testing is done. But not all research includes that type of test result, and not every protocol allows for return of results. One example I want to highlight is the All FTD study. They do allow for genetic counseling and CLIA certified testing with return of results. And Penn is a site, which is why I have experience with that, but it's actually a consortia study with sites throughout the US. So there's two main types of research. There's observational research and interventional clinical trials. And I just want to define what they are, because if you're looking for research opportunities, what you're going to get out of them will depend on which category they fall in. So observational research is really research where we watch and learn from you over time. There's no intervention, there's no drug or anything like that you're getting. It's really where we just follow a large group of people over time and learn more about a disease trajectory. And this can be really helpful because it can help us better understand how to diagnose earlier and inform treatment development in the future. And sometimes studies like the All FTD observational study can include the option to learn information that you may feel is beneficial, like genetic results or getting genetic counseling, but typically you're not expected to directly benefit from observational research. It's sort of like you're doing something for the greater good of science. On the other hand, clinical trials are interventional. And so from a drug standpoint, this can be getting a drug or placebo, which would be like a sham treatment. It's not a real treatment, to try to study whether this drug is safe and or effective, depending on what phase we're in for a trial. Every trial has different asks of participants in terms of what you'd be required to do, how frequently you'd have to come in, what risks you're taking on, what the potential benefits are. And every trial has different inclusion and exclusion criteria. Some of the research trials are gene specific. And so you might have to know your genetic status before you know if you could be eligible for a trial. And because of that, some research trials are offering genetic testing through the trial. So it's important to keep in mind, what genes are going to be evaluated and where they're going to store any of those results. Is it going to be kept just in the research? Is it under research ID? So these are things to keep in mind if you end up pursuing genetic testing through research. Some frequently asked questions from the research side. If I join a research study and give a sample for testing, can I definitely get the results? As I mentioned before, not always the case. It depends on the protocol and what type of testing is being done. So make sure you ask those questions from the get-go. If you want to join the research but don't want to know your results, can you participate? Sometimes, yes. So for example, that study All FTD I mentioned, you can absolutely enroll. You can get genetic counseling and still choose not to learn your results and remain in the study. There are other studies that are like that as well. Some studies might require you to learn your results, but with observational studies, typically they don't. If you undergo genetic testing through research, you have an added layer of protection in many cases in that the results are not kept in your medical chart, but rather in research files. But So the reason that's an added layer of protection is that sometimes if you apply for a life long-term care disability insurance policy, when they're doing their medical record review, what they'll ask you is list all of your medical providers in this state range, and we'll request records and review records. Well, if you see me through research, you're not going to list me as a clinical provider, even though I could see you clinically for the exact same visit with the exact same conversation. And so that's an added layer of protection there. But if one of these companies point blank asked you, have you had genetic testing? You'd absolutely still have to answer that honestly. We don't want anyone committing insurance fraud. And so what I've heard from families is that it's helpful if they can give the minimum information necessary when answering questions. So if they say, do you have a family history of neurologic disease? The answer is yes, but you don't have to say, and we know it's genetic, unless they point blank ask you that. So obviously you need to answer honestly. Nobody wants to commit insurance fraud, but being careful about what information you're disclosing, as Jalayne was saying, being careful about what you disclose and who you disclose it to. And sometimes people wonder, even if I go through research, would I ever need a report with my name on it? The answer is sometimes. So in order to actually take medical action on a report, like if you wanted to go through alternative reproductive planning or sometimes even join a clinical trial, you might need a report with your name on it so that they know it's an accurate report before they'll make a medical intervention. And sometimes family members might need a report with your name on it to be able to pursue their own testing. So it's important to talk to a genetic counselor about what your needs may be, and they can guide you through this. So just generally, sometimes it's helpful to think about how do you get ready for this genetic counseling and testing process. Make sure that you gather any information you can about your family history and obtain any genetic testing reports that your family might have had. And really think about, this is the key thing to bring up, really think about what insurances you have in place and what you might want someday before you make that appointment, if it's going to be a predictive genetic counseling appointment. If you're someone who already has a diagnosis, that part isn't as important. And so consider seeking advice from a professional in the financial planning or insurance planning world before you make that appointment. You should also think about whether you're comfortable going through the clinical route or if you want to consider any research opportunities that might be there before you schedule an appointment. Think about who you want there as your support person, collect your questions for the counselor, and really, again, be cautious of who you disclose this information to. So when thinking about your support person or people, making sure it's people you trust. Sometimes people ask about logistics. So just a quick overview here is genetic testing can actually be done on something as simple as a cheek swab. So that's a buccal sample. It can also be done on saliva where you spit into a tube, or on blood, just as accurate with each modality. How long results take to come back depends on what testing is being ordered, where it's being ordered from, like whether it's through clinical care or research. But typically you should be able to get results back within about a month when we're doing an initial focus test on genes related to FTD and ALS. And again, cost depends on whether you're going through clinical care or research. So just to really compare clinical and research counseling and calling out some elements that are unique to privacy considerations here. Some of the key differences are related to cost. So again, whether it's to the patient or to the research team, the time commitment and activities required. When you're going through clinical care, you're just meeting with a genetic counselor, having testing if you want it, going over results if you want it. Whereas through research, you might be asked to do other activities, like through those observational studies, for example, giving blood samples or having a brain MRI or answering cognitive questions, or doing a drug trial, you might have an intervention. From a privacy and confidentiality perspective, thinking about where records are being stored and whether your name is on it, and thinking about what actual genetic testing is being offered. Is it CLIA certified, that clinical grade testing, or not? That has implications for how much information you're allowed to have disclosed to you, and also how broad of testing is being completed. If you're going through clinical care, your genetic counselor can work with you to make sure that the right set of tests are being ordered. If you're going through research, what genes are able to be covered might be predetermined by the study. So for example, if you're screening for a clinical trial, they might only be doing genetic testing for their gene of interest. So really important to keep that in mind. Just some other brief things to consider. Even though the turnaround time may be similar for the test results, your wait times for getting into the clinic or into the research study may differ. So that's something you can ask about. Again, a reminder that you can participate in some research studies, but not have to learn your status. You can see a genetic counselor clinically. have the testing ordered and still choose not to learn your status, but it's really important to talk to your providers ahead of time about some recent changes with laws related to patient portals and accessing test results through patient portals. So you might have noticed that now if you're getting care in the US, there's more automated result notifications when you have results back from any medical test. And genetics is no different. And so really important to think about whether you're comfortable seeing your test result through your patient portal and having that conversation ahead of time with your care team to make sure that they can block that result from auto releasing to you if you're not sure if you want to get the results or you don't want to get them that way. It's also important to know that if you don't think research is for you right now, but you definitely want to undergo counseling with or without testing, you can go the clinical route and then later choose to enroll in research. It's not like you have to go through research from the get-go. Just want to briefly touch on how discrimination concerns can extend beyond insurance and beyond just genetics, and Jalayne highlighted some of this earlier. But sometimes discrimination can come in other ways. So people can be worried that if they're found to have genetic risk for a condition like FTD, that they might experience social differences with their significant others or future partners or friends. They can also be worried that even if they don't worry about getting fired from their employer because their GINA protects you if you're found to have genetic risk, GINA protects you from your employer asking for that information and using it to fire you, for example. If your employer somehow finds out, it can be very hard to prove that the way they're treating you is due to genetic discrimination, because an employer can say your performance has changed or something else is going on. So you have to be really, really, really careful about what your employer is able to discover, such as what you communicate to coworkers and bosses, what you may post on social media and things like that. Because if your employer discovers this information, again, it can be hard to prove that that's what they're using to treat you differently. And again, just to highlight, like Jalayne mentioned, there's a difference between your genetic diagnosis and a clinical diagnosis. Your employer should not be made aware of your genetic risk, but if you ever become symptomatic and you get a diagnosis of FTD or ALS or whatever it may be, then it can be important to disclose that to your employer, because under the Americans with Disabilities Act, they might have to make accommodations for you if you want to continue working. Again, Jalayne started to highlight the gray zone of what if I'm found to have genetic risk and maybe I have some changes, but I don't have a formal diagnosis, or as biomarkers improve, maybe I have a biomarker diagnosis, but not a clinical diagnosis. There are gaps and protections for these people falling in that gray zone where they're not fully asymptomatic, but they're not formally diagnosed. And so it's really important to just, again, stay in touch with your providers about your concerns about these things and be careful about what's being communicated and where. And this is an area of active research in ethics and in policy from people like Jalayne and my colleague, Emily Largent at University of Pennsylvania. And, we need to do better to make sure that these protections are in place as diagnostic techniques advance. So these are new challenges that are arising, and that's why I'm so grateful to the IFTD for spotlighting this topic today, because this is an area that really affects lots of people, and it's an area that's actively evolving. So my biggest take home is be thoughtful about how, where, and with whom you share your and your family's genetic and other diagnostic information. Because again, emphasis, this is on the family. If one person shares information about the genetics in the family, that can reveal information about more than just them, because this is a family affair. So in summary, genetic counseling and, if desired, testing can be accessed via clinical care or through research. Genetic counseling does not mean you have to proceed with any testing. There are benefits and limitations to these different approaches, so feel free to take your time and think about what's best for you. Whenever possible, we like to start with diagnostic testing, that person with FTD or ALS, because then that informs the rest of the family. And there's different privacy considerations and confidentiality considerations and other legal considerations when we're in the diagnostic realm versus the predictive realm. So if you have questions or want to talk further, ask your neurologist or primary care doc for referral to a genetic counselor. There's also resources here like the Find a Genetic Counselor tool that you can plug in where you live and whether you want an in-person or virtual visit, and it can help you get connected with a genetic counselor. And I include some other resources here that I encourage you to look through. So thank you so much to the AFTD for having me, and for you all for listening. And I hope that there are good questions coming our way.
All right, so thank you so much for your very informative presentations, Laynie and Jalayne. At this point, we'll try to answer just a few questions. We're short on time. So if you do have a question, please feel free to submit it or contact our helpline. The helpline team of trained professionals is available for any additional help and to answer any of your questions. As we're lining up our questions, I just want to share some of the few resources that AFTD has available for those impacted by familial FTD. There's all of this information and much more on our website. So going through to the questions, let's see. Sorry, my screen just disappeared for where the questions are. So Matt or Shayna, can somebody read the questions off to me because I can't see them anymore?
Sure. I guess I'll start from the top. If insurance is purchased and paid for prior to a diagnosis, is there any remaining concern about a claim being denied or held up by the insurance company afterwards? What experience have other families had in this area?
Okay, can we have Laynie and Jalayne join us on screen?
I think we're here.
Okay, please, I'll
Yeah.
leave that over to you then.
Yeah, no, it's good. It's a little confusing coming back and forth. So I can go ahead and respond to this. I'm going to be a total lawyer here and say it depends. And it depends on the policy language and it depends on what the restrictions are on being able to access and use the benefits underneath a given policy and the type of policy type, right? So this may differ. This may be another area where there's significant differences between life insurance, long-term care insurance, disability insurance, and health insurance. However, typically, the types of concerns that Laynie and I have discussed are those that occur prior to obtaining a policy under one of these types of insurers. And again, it's important to recognize that we're talking about private insurers here. So one good way to sort of understand what that potentiality could be is actually to contact the insurer, or if you're getting, for example, your insurance through a employer, to actually have your human resource manager help you identify the best way to talk and get information about what your policies are. And you can even just talk about potential benefits without disclosing why you're asking about that.
Okay, thank you. And then one other question, I think we only have time for one more. But if you think you're being subjected to employment discrimination, what kind of an attorney or legal resource should you get involved?
I guess that would fall into my camp unless Laynie would like to take on the task of talking about legal practice. So yeah, I would really look for an attorney who has experience in the employment context, so labor and employment, and specifically somebody who might have a focus on discrimination. You can find attorneys either through the American Bar Association or your state bar association. So every state has a licensing board called the bar that makes sure that attorneys are practicing, and that would be the best source to go to find an attorney with that context, unless you have friends or family that might have a better sense of who's in the legal field in your area. You definitely want to look for an attorney that is practicing in the state and the geographic area that you're at because of the sort of nuances around state laws in this area.
Thank you very much. And I'm going to squeeze in one quick question. Can you avoid privacy and confidentiality concerns by going through testing like 23andMe or Ancestry.com? Laynie, that one's yours.
Yeah, thanks for asking that one, Kim. So just to back up a moment and give some context, unfortunately, the testing is just totally different. What we would be testing for FTD versus what you can get through something like 23andMe or Ancestry.com. These direct-to-consumer testing companies are not often using CLIA certified, so that clinically grade type of federally regulated test. Sometimes people may try to interpret their raw data through a third-party company, and we know that there's a high false positive rate when they do that. So it's not really a result you can trust. So even if you did that testing and brought that testing to a genetic counselor, they would encourage you to redo it through one of these CLIA certified clinical grade tests anyway. So it's not really going to get you around the problem.
Thank you. Thank you. So anyone who submitted questions under an anonymous tag, please send your questions to the helpline so we can respond to them later. And I want to say thank you to our guest presenters, Laynie Dratch and Jalayne Arias, and thanks to everyone who submitted your questions, and a special thank you to Aviato Bio for your generous support for today's webinar. Please let us know if you have any comments or questions about today's presentation. And if you have any further questions about any aspect of FTD, please contact the AFTD helpline using the information on the left side of your screen. And be sure to sign up for the FTD Disorders Registry if you haven't already. Visit ftdregistry.org to learn more. Thank you very much.